Okay, this is Larry McGee, and we're back for the sixth and final video on the Colorado buyer listing contract. Uh, Although there's some things we're going to talk about with some additional documents, I did forget to mention here at the very end under web signature. Be sure that you go back in here and enable the web signatures, otherwise your people aren't going to be able to do very much. I always just enable web signatures and web initials up here in this little window, which we can slide down here. In this little window here, enable web signatures and web initials, and just save that. And now we've enabled web signatures and web initials anywhere necessary in this contract. So that should wrap up the contract itself. We're going to go back up to the top, and again we'll hit save just one last time before we move back. And I'm going to hit the back arrow here. Actually, what I'm going to do is close this contract. And I'll go back here to this window that says exclusive right to buy listing contract for Joseph and Mary Blow Living Trust. I'm going to create a new contract. I'm going to go up in here and open this window, create new contract, and that's going to give me a window with additional documents. So there's a variety of documents we can add to this particular contract. I think the first one that we're going to talk about is definitions of working relationships. This is pretty simple. It's oftentimes not used. There's some discussion about whether it should or shouldn't be. Certainly if we're going to have a buyer agency contract, all of that information that's in here should be contained in there. However, it's possible that your consumer is uncertain about what they should do. If that's the case, I would give them the definitions of working relationships, and then let them acknowledge the receipt, and then again create that web signature enable. I'll just pull that back down here so you can see it. We're going to save that, so we've enabled their signatures, and if they don't want to sign it, then on this date the broker provided with the document via electronic or face-to-face retained a copy for the broker's records. People are funny about signing things at time. We understand that. Again, I would remove NA. Just get rid of it as just a matter of course. If there's anything in here, any document that needs NA, you should do that manually. And again, you can save this document. And we'll move out of this document. We'll go back in here to a brokerage disclosure to buy. Well, we won't even use that because we've done agency. Again, if we need to extend or extend the contract with broker, we have this form. We'll take a real quick look at it here. Just briefly, we're going to amend the following contract, which in this case would be the exclusive right to buy listing contract. So we click that radio dial right there, put in the original date, March the 9th in this case, between the brokerage firm named below and undersigned, and the date ending is extended to something else. If we want to extend our relationship another couple of months, we can do it here. There may be something else in terms of a price change, price or rental rate is changed to or amends the contract anyway financially, we can do it here, or additional amendments. Again, not sure what those might be. In most cases, if we were going to extend this type of contract, all we'd really be dealing with is dates. And again, go ahead and enable our web signatures, bring that down here, enable it, save it, and again save the document, which I will do. Again, this is the agreement to amend extend contract. This can obviously be used in a variety of situations where we have contracts with consumers. The other, I think, important thing that shows up here in our Oliver Frascona has provided us with a variety of documents and clauses as part of our company situation. We update these every year, and these are the 2014 versions. I would suggest you take a look here at brokerage disclosure regarding new construction contracts, and we'll take a quick look here and at this document. Obviously, again, we've got a date. We can go in here and put this date. Now, if I felt that my people wanted to buy a new house or there was a reasonable chance of it, I would probably go back in and add this document. Now, I've already made a note of it in the original document under additional documents. Really no reason why you shouldn't just get this signed as a matter of course, because consumers many times will look at a bunch of resales and suddenly decide they want a new house. I think this document is very good about giving our consumers a heads up on a variety of issues that are a little different with builders. The first one being that the builders generally use their own contracts. So sometimes contract may purport to say the seller retains certain deposits even in the event of a seller default. Now, deposits or earnest money deposits, we need to be extremely careful with that on behalf of our clients. Often builders will take earnest money deposits and place them in their operating account. They don't necessarily maintain a trust account. I think it's reasonable to make sure that deposits are maintained in a trust account at a viable title company. And by viable, again, some caution, because it's in very recent memory we've had a large title company simply go away, creating a variety of problems for everyone that had deposits on file or checks that had not been cashed. Builders do all kinds of interesting things with their contract: lack of specificity, no meaningful deadline. It's very difficult for a builder to create a meaningful deadline because all kinds of force majeure, acts of God, weather, whatever, may delay projects. Closing based upon temporary certificate of occupancy, that may not be something your people want to do. Limited inspection rights, limited title evaluation rights, warranties that don't necessarily provide good procedures or enforcement, lack of authority of sales staff. Please remember that that nice person sitting there writing this contract at XYZ Builder is not the person who has the authority to sign the contract. The contract's going to go into a corporate office somewhere where it's going to be either accepted or countered in some way. Again, a variety of issues. I think this document is great to bring your consumer aware, or make your consumer aware, that there are a variety of issues with builder contracts that are different. A big one down here is expansive soils. Make sure we talk about expansive clay soils. Most builders have figured that out by now, but a few haven't. And then we talk about the builder going bankrupt. And that certainly has happened in the recent past. Certainly could happen again in the future. Many small builders sometimes simply can't withstand a variety of economic difficulties. So if their earnest money or upgrade deposits are hanging out there, your client may be in a position to lose that money. And again, this is an area here where the buyer is encouraged, advised to consult with legal counsel before signing any contract. I think with builder contracts, this is a situation where we may want to often encourage our consumer clients to speak with legal counsel. These contracts are written by the builder's attorneys for the builder, in favor of the builder in most cases, with the exceptions of any Colorado law that requires favoritism to the buyer. And it's a contract that we're not generally familiar with, so it's difficult for us to provide any sort of counsel to our consumer. It may be very wise on the part of the consumer to have a contract reviewed by an attorney before signing. Again, we get back in here into web signatures and go ahead and click the little box, and there's our little web signature box down here again, and we're going to click that and save it. And we're going to save this document. That's going to give us some additional documentation for our consumer on our normal buyer listing. One last one. I said there was two, but there's really probably four that are worth looking at. This one is a buyer addendum, or a buyer disclosure to buyer tenant. It speaks to a lot of things that are really in the contract, or sometimes in the contract to buy-sell, including due diligence, use of professionals. Certainly if a consumer client wants to have their brother-in-law handle the inspections, that is up to them, but we would certainly encourage that they have professionals do any kind of examination of the physical property or the title documents. Remember that title documents are something we can explain, but we can't offer an opinion on. Property repairs and improvements, homeowner's warranty, loan objection, a variety of things that it may be worthwhile to bring to the attention of your consumer. I don't necessarily recommend that we use this form all the time, but there may be certainly occasions where you think it may be wise to do so. If so, complete your dates accordingly and add the right signatures. All right, well, that concludes the discussion on the buyer listing or exclusive right to represent the buyer contract. Hope this has been useful for you. We're going to come back and create similar videos for the other major contract elements that we deal with in our business. Again, thank you for your time.